Hello and welcome to our second plenary panel of the ICONS, International Society of Public Law, fourth annual meeting. And we are truly grateful to the organizers here at the University of Copenhagen for taking such good care of us. Is it okay now? Yes, wonderful. So the second plenary panel is entitled High Courts and Political Power, a conversation with three prominent jurists. And prominent they are. I mean, we have here an A-team of prominent jurists. I am not going to introduce them to you, just very briefly, because if I do list all their credentials and accomplishments, it's going to eat up all our time. So I'm just going to quickly say I'm Ron Herschel. I'm a professor of political science and law at the University of Toronto and the University of Göttingen in Germany. To my immediate right is the Chief Justice of Canada, the Right Honorable Beverly McLachlin, who is, I think it's fair to say, one of the most... Yes, you want to clap your hands? That's...
You don't know what we're clapping for.
Who is, I think it's fair to say, one of the most distinguished jurists of our generation, and by generation I mean a generation. She was first appointed to the Supreme Court in 1980, the Supreme Court of Canada in 1989, became Chief Justice, the first woman in this distinguished position in 2000, and I think most recently announced her looming retirement in December. So we are talking here about almost 3 decades of distinguished service. To her right is Judge Marta Cartabia, who's really a true intellectual and a major author in the area of public law, Italian and comparative. Yes, we need to clap. And she is joining us today not in her capacity as a distinguished academic, but rather in her capacity, well, that too maybe, but rather in her capacity as the Vice President of the Constitutional Court of Italy. She was first appointed to the Constitutional Court in 2011, is that correct, Marta?
Perfect. And
was promoted to the Vice President position in 2014. And to her right is another distinguished jurist and intellectual, Judge Andras Shayo. Am I pronouncing this correctly? Currently with the Central European University in Budapest, Hungary, and we all know who Professor Shayo is. If you attend this conference, you must have encountered one or more of his writings. And he is here in his capacity as a judge of the European Court of Human Rights, on which he served/serves since 2008. So he announced his retirement a few months ago, but or stepping down, but he just told me that he's still working on some decisions. So I guess he's still here in his capacity as a member of the European Court of Human Rights. So claps again to our distinguished panel. Thank you all for coming, and we are all tremendously honored to have you. What we are going to do here in the next hour and a half is to engage in some semi-formal conversation or interview with distinguished judges. And so we are going to begin with a few questions that I'm going to ask you, and then ask you to address those in turn. And then towards the end of the session, we are going to take some questions from the audience. So the first question, since again the theme of the conference is the interface of courts, power, public law, or the intersection of high courts and high politics, the first question I want to ask you is, so over the last 20, 30 years, we've seen around the world a tremendous increase in the power of courts, in the political significance of high courts, constitutional courts, supreme courts, international courts around the world. At the same time, over the last 3, 4, 5 years, we've seen some pushback against this trend. And, you know, we can title this pushback with all sorts of fancy words: nationalism, particularism, populism, conservatism, all these things, but we all know what we are talking about, and we've seen this in numerous countries around the world. All of you are, you know, all of you have sat on numerous political high voltage cases with significant implications, from the Quebec secession reference or the Senate reference in Canada to electoral reform in Italy, and numerous important cases on the European Court of Human Rights. So I want to ask you, how do you view this tension in general, and in particular the position of your own court with respect to the political environment within which it operates? Chief Justice McLaughlin.
Well, thank you very much. It's a very pertinent question that goes to the heart of constitutional democracy. We in Canada have had a story over the last 30-some years which has seen the position of our court relative to the legislature and the executive branches of government alter significantly. And before 1982, our courts played a much less public role, shall I say. They were important, but they seldom were asked to resolve issues, political issues, occasionally important constitutional issues, but they weren't very much in the public eye. In 1982, that changed when Canada repatriated its constitution and adopted a Charter of Rights and Freedoms. And what the Charter of Rights and Freedoms meant was that all laws and political or executive action had to conform to this Bill of Rights. And a citizen who felt they did not could bring an action to have a law set aside or have an executive decision set aside because it didn't comply with this charter, with the Charter of Rights and Freedoms. So we saw suddenly a huge surge of activism, mainly in the human rights area, but along with the charter there were guarantees adopted for Indigenous peoples and other guarantees. And people availed themselves of this. The courts responded that I was not on the Supreme Court of Canada during this period, but much to people's surprise, the court adopted an open, progressive view of rights and took a very hands-on approach, struck down a number of laws. It's called striking down. Actually, the mechanism is the court declares the law to be inconsistent or the executive action, and then it falls under Section 53 of the Charter. But the public saw the court striking down these laws, something they had never seen before. And this provoked a lot of debate, and rightly so. It was a fundamental change in our Constitution. And people said, although before the Charter this had been predicted, people thought, well, the court has always been so conservative. They've never done anything very much to rock the boat. So it'll continue that way. In fact, the court adopted, as I said, a positive and substantive approach, a liberal approach to rights, and the court became seen, in many people's eyes, as an institution that was striking down the laws of the democratically represented people. This produced a a lot of criticism in some quarters. It also produced praise. There were a lot of people who said, what's wrong with requiring government power, be it legislative power or be it executive power, what's wrong with requiring that power to be exercised in conformity with the Constitution? Now, the answer to that is probably nothing, but people, some people said, well, what is it about these 9 people who are on the Supreme Court of Canada who've never been elected that gives them the right to do so? So right away, the accountability and the credibility of the Supreme Court of Canada was on the line in a way it was never on the line before. So it would be fair to say, looking back, that the first decade and a half after the charter cases started coming through was a time when there was a lot of public and debate about whether the court was taking too dominant a role in our democracy. And the phrase judicial activism was very often applied to what the court was doing. I personally couldn't figure out exactly what that meant. For the most part, it seems to mean I didn't like the decision, because the same people who were accusing the court of judicial activism would turn around and say, oh, it did exactly the right thing when the court decided in their favor. But it was a difficult time. I think that most people would agree things started to settle down in the late 90s, and when I became Chief Justice in 2000, and in the decade and a half since, I think we've seen a quieting of the criticism. Not that it's not there, but we don't hear the term judicial activism or out-of-control judges and that kind of thing being used anymore. We went through that, and I think we came through it with the confidence of the court intact. One thing I realized is that courts have to maintain the public confidence in this kind of a situation. And I think that people realized that we were doing our best to decide the cases as fairly as we could, having regard to both parties and what society needed and what would help society to function well within the constitutional framework. So it was a combination of principle and pragmatism to some extent on the remedial end. For example, on the remedial, am I going on too long? I'll stop. But we found that remedies were really, really important in maintaining public confidence. And I'll give you one example, and then I will stop. But there was a language reference. Canada is constitutionally bilingual. One of the provinces or states, Manitoba, was held to be required under the constitutional guarantee to publish all of its legislative acts going back over 100 years in French. They hadn't been doing this for 100 years. They'd been doing it in English only. So the whole body of Manitoba law was unconstitutional. Now that's a pretty big, I say it slowly because that's huge. And so under the literal wording of the charter, that law was null and void. Now all those laws were null and void. There would have been a huge legislative vacuum. So the judges at the time, I wasn't on the court, but the judges at the time said, this can't work. We have to come up with something that is pragmatic. Now the wording under our Constitution is that the court is required to declare whether the law is consistent with the Constitution. The answer of the court was, no, it's not consistent. But they introduced a legal technique of saying, but we will withhold our declaration. In 3 years' time, we are going to declare that. Now, we all know that that is, everybody knew that that was really just a pragmatic way to give some time to the people and the government of Manitoba to translate its laws into French and to bring them up to the constitutional standard. And in fact, they came back and got a couple more extensions, but it worked well. In the end, the laws stayed in place, and in the end, they were all bilingual.
Thank you. So we have here a half admission of principled and pragmatic decision making. And with that, Marta.
Thank you. First, I would like to stress some differences in the mission of the Constitutional Court and the Supreme Court. Constitutional Court of Italy, as well as in other European countries, were set up after World War II with the mission of exercising judicial review of legislation. That means that the problem that you faced starting in 1982, yes, it was there since the beginning, and the tension between the Constitutional Court and the other democratic institution was there since the beginning. And in fact, at the origin, it was a really hard time for the Constitutional Court because, first of all, the implementation of the court was postponed 8 years later, the entry into force of the Constitution, and this was not just because the Parliament was lazy, it was on purpose. It was an institution that was introducing an aristocratic element into a democratic system, as Sabino Cassese writes in his last beautiful book about democracy and the limit of democracy. And also because of a number of reasons, our constitutional mindset was based on two major pillars, sovereignty of parliament and a very weak judiciary. So a constitutional court with the power of reviewing legislation and striking down the parliamentary legislation was something that sounds really at odds with the democratic principles. So I would like to start from there and to draw a lesson from history. In such an inhospitable environment, how did the court react since the beginning? It is interesting to review the first decision of the court. It was a decision about freedom of speech, a very important issue, a very important individual right. And the legislation under review was an old one coming from the fascist period, and it was a piece of legislation requiring some authorization for circulating leaflets and handouts in the population. So the Italian Constitutional Court took as its very first decision a decision that went to the core of the democratic values and rights. It was not immediately against the parliament that was in office in that moment. It was an old piece of legislation, and it was indeed something that expressed a general consensus of the population that were in need of having a more liberal country. So, in a way, it was a cautious but also a very bold decision. The decision was of unconstitutionality, but it was also a decision that were against old legislation that everybody agreed that was not longer possible to maintain in our system. What kind of lesson can we learn from here? Oftentimes we have the feeling, and we can listen to comments that courts are praised when they are modest, self-restrained, classical rather than romantic, and many other definitions that are around the world. I'm not sure that I agree with this kind of appreciation of the work of courts. Courts indeed are required to act within the limits of their power, and they have to be blamed if they go beyond that. But within that limits, the courts are required to do their job, not to overstep parliamentary decisions, parliamentary power, but to take important decisions within the limit of their power is indeed what courts are required to do. But I think that when people criticize courts for being too active, too proactive or whatever, in fact, they are criticizing the fact that they do not take into consideration that courts are not alone. They cannot do all the job. In that case, in the Canadian case, they accepted the fact that the Parliament was required to change the law. They couldn't leave the void on such an important point. And I think that the elaboration of remedies is very, very important. The court sometimes has really the feeling that we have to take very unpopular decisions. The most relevant in Italy in the last few years was the decisions of the Constitutional Court amending the electoral legislation. This is really something strong because it goes at the rules and the procedure of the democratic institutions. But we didn't rewrite a new piece of legislation. Let's put it in this way. If the legislature, the parliament, is able to take a pen and a white sheet of paper and design a new architecture for the electoral system, the courts has only an eraser in its hand, can only change and fill in the gaps of small parts. Indeed, the court is changing the legislation, and Mauro Cappelletti was asking years ago, are judges legislators? And he answered, yes, they are. But they are a very special kind of legislator, law-making institution, with an eraser, or if you want, a delete or backspace key on the keyboard. They cannot write everything, and they have to take into consideration that the rest of the job can be done by other actors, the political ones and other courts and other institutions at the national and international level.
Thank you very much, Marta. Andres.
May I start with a short description of the difference between the national courts and an international court, and in particular the European Court of Human Rights. The nature of this court is certainly decisive for what it can do. And the meaning of political is really different, because in our case, the political power means not only a majority political grouping in parliament, but a nation state. So the problem for an international court is not only that it will perhaps embarrass a majority of the day or a minority of the day in government, but embarrass national sovereignty and national pride, which of course is very often mobilized by the government of the day. So this is a specialty. Now you know, I suppose, that even coming from other continents, that this court is unique because it allows an individual to stand up against a sovereign state. This point number one, and therefore it will be an individual most likely a citizen of that state who will, in case of finding a violation, be the cause, the reason, the point of departure for the embarrassment, which, by the way, more recently resulted in attacks by national governments on applicants, and lawyers are being accused of betraying the nation. It's just a little footnote to what political power and courts mean. There are others who may suffer, not just the court. So this is the particularity here, that we may end up being confronted with one sovereign state, and in fact, very often with 47 sovereign states. Very often, in major cases, they tend to exercise group pressure simply by becoming third parties. And you know, it's really unpleasant to have a coordinated action, which is part of the situation. It's very political, because these coalitions are made on the basis of some kind of political understanding. Now, you would say that because of the enormous delay in some of the cases, the pressure is diminishing, because we unfortunately, very often we deal with cases which started 20 years earlier. It took 10, 15 years to get through the domestic levels of jurisdiction, exhausting domestic remedies, and then, because of the caseload, it takes impermissibly enormous time to digest the case in our court. So it may very well be that the government, which might be embarrassed, or the political movement that might be embarrassed, is already out. It may very well be that after 20 years they are back in. So not always that you have that kind of excuse. So once again, a special problem related to power is not just political power to have legitimacy or being delegitimized, but also a broader issue that is national prestige. And that's very difficult to articulate, but it is, I think, part of the game. And I think that's the specialty that I wanted to add to this.
Thank you very much. Let me follow up on this. And I thought, since the Chief Justice of Canada is here with us, and Canada is, by the way, just turned 150 a few days ago. And since the Chief Justice of Canada is here, and Canada is arguably one of the most multicultural constitutional democracies in the world today, about 20% of Canadian population is first-generation immigrants. In my home city of Toronto, it's close to 50%. So this is an issue of, the issue, let's call it, how we live together, or how to live together, as the European Court of Human Rights put it in the SAS decision, the challenge of multicultural accommodation, the tension between national meta-narratives and the particularities of nationalism and sovereignty, against the empirical reality out there of increasing diversity and claims of diversity based on religion, ethnicity, race, language, sexual preference, and so on. So I wanted to ask you, and maybe we'll go in the same order, and the next question will turn things around. What's your vision of the role of courts and the role of public law in dealing with this increasingly burning challenge of how to deal with diversity, obviously in Europe with the most recent immigration and refugee challenge, it seems that this challenge is here to stay. So what's your vision of all of this?
I think the courts play a very important role. Canada's history is one of successive waves of immigrants who came to join our First Nations, our Indigenous people. And it's a history where we see that with almost every successive wave, the first step was, the few decades was a pushback by the population that had established itself. Rejection, stereotyping, discrimination. So we've been through this so many times with all our waves of immigration that we now realize how arbitrary and silly it is, I think, if I can use that word. And most Canadians have come to accept, and rather than trying to, there are two responses to diversity. You can build a wall, eject people, say you're not like us, therefore you don't belong. And the second response is to say it's here, it's part of us, it's here to stay, in Canada's case for certain, and we like it. It's what we need for our economic future. And so Canada has taken a lot of steps to build an embracive culture, a culture that embraces diversity, that diminishes discrimination. With the adoption of the Charter, Section 15 is our equality clause, and it says that laws and governments cannot discriminate against a person on the basis of their race or their ethnic background or where they came from. And that is not just citizens, that's anybody who's in the country, including people who may have been there an hour or a day or 5 months. So that binds government. The court has found itself in a pivotal situation in interpreting Section 15, and the dominant principle or approach the court has taken is one of accommodation. In other words, when cultures clash, let's say it's a religious case. We had a case where a Jewish person wanted to put a sukkah on his balcony, and the condominium law said no. We ended up saying he could, but we considered very carefully the options. Another example is a recent case, last few years anyway, where the question was whether a woman who was testifying in court, a complainant in a sexual assault trial, could wear her niqab, her face covering, during the trial. Now, this woman alleged that she had been sexually assaulted by 2 men, and she was going forward. She went to the police, and after the investigation, the prosecutors referred it to trial, and she was at the preliminary inquiry stage, which is the first preliminary stage. And she said to the judge, through her lawyer, that she wished to keep her face covering on while she was testifying. That became a major constitutional issue, which went before our court. And there were 3 possible answers. One is you can never wear a face covering in court. One is that you're always entitled to wear a face covering in court because it's your religious freedom if you have a sincere belief. And the third is a compromise, which says we've got 2 rights in conflict here potentially. But potentially is the important word, because if you put it at a really abstract level, you say, oh, there's a conflict that's got to be resolved, all or nothing. But if you say potentially in conflict, you put it in the context of the particular situation. So we said the fair trial right is at stake on the lawyers were, for the defense said, we're entitled to cross-examination under the Constitution and to test the witness, and we can't properly do that if we can't see her face. And they produced studies that showed that in some cases this might be important. The woman's lawyers said, and the Crown said, we need to respect her religious rights. So you have the conflict between fair trial, religious rights. In the end, the majority of the court said we said in 90% of the situations where they're asking her questions, it isn't going to matter because it's going to be fairly routine things that are not directly in controversy. But if a situation arises where the judge says, I think the fair trial right is going to be compromised, then the judge could require her to remove her face covering, perhaps putting in some other measures to protect her privacy as much as possible. And so that is an example of how we would say we compromise these rights. And in fact, what was a huge issue in the press, and many op-ed pieces saying it has to go all or it has to go nothing, in the end it kind of just has died away, and we haven't heard very much about it. So women do go into court with their face covering, but they know that if it got to a critical point where their credibility was at issue, the judge would have the power to say, I think we have to do something else here. And the system seems to have adapted in that way. We have something under our Constitution which is called Section 1 of the Charter. So the Charter gives you all these rights, freedom of expression, freedom of religion, liberty, etc., all the usual. But it starts off right out the gate by saying the state can limit those rights insofar as this can be justified in a free and democratic society. So what is put in place by this document is a way of balancing rights. The state can come in and say, yes, you have freedom of religion, but you can't use that religion in a way that hurts someone else, and we're going to pass a law that says that, and the court will uphold it if that's reasonable. So this mechanism in our Constitution has proved very, very helpful in dealing with conflicts that arise between different and diverse groups.
Thank you very much. Marta.
Thank you. So Italy is becoming more and more diverse and plural. It used to be, like many other European countries, much more homogeneous from the religious, linguistic, ethnical, and whatever point of view. And indeed, we are experimenting new way of accommodating diversity. But in a way, I think that the result is not so far from the Canadian experience, although I would like to point out something that we, all European courts, can learn from Canada as far as I understand. Indeed, there is no way of supporting a discriminatory measure against anybody. In the last year, I have been in charge of writing for the court the opinion against the 2 regional laws discriminating religion's denomination as far as the buildings, mosques were the issue about that. So where there is an open discrimination, the only way to approach it is to strike down the legislation. But many other cases are much more tricky. And those are the cases where you have competing rights and values that require balancing. And the Constitutional Court has elaborated a theory of balancing rights and values in the Constitution, which presupposes the possibility of limiting those rights without ranking in an abstract way which are the rights that should prevail. Freedom of economy or freedom of religion is not in the theory that you can rank rights, but you have to balance in the concrete case. And in such a way that all the rights and the principles are required to suffer some limitation, but no one of them should be completely sacrificed in order to affirm the others. But I think that this instrument, balancing based on reasonableness, proportionality, and all the other judicial arguments that we know in all the courts are very common. I think that there is something in the Canadian case law, and I speak under the control of our Chief Justice, that interests me a lot, and I think that we should explore a little bit further, and is the idea of reasonable accommodation. I think that in that practice, let's take an example, because we had the same in Italy, not in the Constitutional Court, but in the Supreme Court. The Multani case, it was the case of the Sikh that wanted to go to school with the kirpan, the knife that the Sikh had to wear, the male Sikh had to wear all the time. In Italy, a few months ago, the Supreme Court of Cassation, so the other judicial body, decided that security reasons should prevail over freedom of religion. In the Multani case, I saw a very interesting answer to the same question. Indeed, Canada have also security problems and concern, but the result was that the kid was required to wear the knife in such a way inside a pocket, suit and so on and so forth, that it was not dangerous for the other kids and the community. So the same case, two different answers. I think that there are a couple of methodological points in reasonable accommodation that deserve attention. First, it is this pragmatic attitude rather than theoretical. It's not so much a matter of principle, is security more important than religion or the other way around, but a practical result that the court is looking for. What is not, cannot be combined at the level of principle can easily, not always, but sometimes it's more easy to find a solution in the practical level. Practical concordance. We could remember that it's on the practice that we can find more option than in the theory. And the other interesting thing is that it is a sort of win-win solution. You have security and you have the respect for the person and his religion's beliefs. There is a cost in this approach, and it is the fact that religious accommodation cannot be written in a rule. You do not know in advance what would be the solution. You have to have the two people meeting in person and find a way to compromise and to find a common ground for this solution. I think that as a general methodological point of view, I would say that our diverse countries, even in the judicial level, require to move away from matter of principles and to try to find out more practical results that can combine instead of dividing and causing more conflicts.
Thank you very much.
Once again, there are specificities when it comes to adjudication in Strasbourg. When it comes to national diversity, we have to find a perspective based on diversity in 47 countries. So it's not only an internal diversity that we have to address, but we have to be aware of the fact that there is no single reaction in the other countries. If you compare the approach of the United Kingdom with that of France in religious education, etc., or you take recent German headscarf developments compared to headscarf in Switzerland, you live in a completely different world. And we have somehow to come up with a rather harmonious set of decisions. Now, having said that, I see here a number of very different problems. One is outright prejudice-based reaction to minorities ethnic national minorities in particular, but also religious minorities. The problem for an international court is that in order to be effective, the attractive thing is to use some presumptions, but the presumption must be based on the assumption that there is a kind of racial prejudice in that society. We had a number of Roma-related cases, and there, gradually, the court was forced implicitly to recognize that in country A, B, C, there is a structural problem, that it is embedded in society and then reflected in governmental practices. And that is a very tough choice, because this is really an affront to national pride. You can do this in many ways, but if you really would like to provide protection, you have to do something, and that took a long time to get there. The second element that I would like to mention has to do again with minorities, autochthonous minorities, because the problem, what is called the migrant problem, but I think this is the first word ever used in this context. So we talk about refugees, people who voluntarily join, many, and you call them migrants. That's the end of a rational approach. Sorry to bring this up, but for some reason I'm really frustrated with this use of the word. So coming back to the issue of autochthonous minorities, again, in the context of Roma, it took quite some time, and it's still limited, to recognize that this can be a different form of life. It's part of the dignity or autonomy of those people, and there some special measures shall be granted. These are caravan cases in the United Kingdom in particular. To use another example where there is a kind of national prejudice, and I'm not sure that there was no prejudice in the caravan cases, but leave that aside, school discrimination, there we moved into an assumption of existing continued prejudice. The third and last example is a case of the Alevi minority in Turkey. We are talking about 7 to 10 million people. And the position of the Turkish government was that there is no discrimination because there is no Alevi religion. In Turkey, everyone is a good Muslim, meaning Sunni, and the Alevi are a culture, and they are supporting that culture. They provide all sorts of facilities. No, but where is the problem? And here, after 10 years of litigation, the court finally found that we are in the position, the court, the European court, to say that this is a religion not because we think so, but because they believe so. And it's a consistent system of belief, satisfies every. And so it's not really the court determining who is a good Muslim. The court is recognizing that there is a religion here. Whether this is Muslim, whether this is Sunni, it's not our business. They are entitled to the same level of state protection that other religious groups who call themselves Sunni, good Muslims, deserve. So here, I think the court took a position, and then, of course, the putsch came, failed, and the Alevi cause failed too, I'm afraid.
Thank you very much for those illuminating and really revealing comments from the three of you. I want now, perhaps, since the theme is courts and politics, direct the third question to politics closer to your institutions, to your own kingdom, so to speak. So in the US constitutional discourse, legacy, etc., people talk about things like the Warren Court, the Scalia legacy are quite common in American constitutional discourse. Can you give us a sense of your own views of this tension between the individual judge or the individual jurist, and obviously the three of you are very good in this craft, and the status or standing or stature of a court as an institution. I'm not looking here for gossip or behind the scene stories, but perhaps you could give us something beyond the official story. Thank you. Maybe we'll go in a different direction than the reverse order.
I'm always in the middle, so I'm comfortable.
We'll start with you, Marta, in the fourth question.
Well, I'm not sure whether I'm privileged to be the first in this round, given the delicacy. You would like me to go beyond the official mantra, but I really would like to start by the standard discourse we have on this matter. And the standard discourse is that all judgments are collective judgments. We have the right to dissent, no question about that, but the primary effort is to come up with a collective, preferably unanimous judgment. And even if you are in a minority, you are expected not only to disclose your objections in advance, but try to improve the draft and try to hint where it could be made better in order not to be forced to voice your criticism. So that, I think, collegiality is a requirement that may determine to some extent the nature of the output or the quality of the output. And of course, quality is a tricky thing, because this very often invites you to get to compromise. You don't want gossip, but this is not gossip, it's just my personal experience in one case where I think the draft was awful. I thought I managed to convince colleagues not to make the worst, not to commit the worst errors. They agreed. We went through this 3 times, which is very unusual. It was still terrible, but I felt that there was so much mutual compromise in it that I felt, being the president there, I brought this together, and I will not write a concurring opinion. I do regret it now, because at the end of the day, it did not shed a good light on my drafting skills. I was aware of the problem, but you know, there are 6 others, and you can't. This is a very difficult psychological situation. So compromise has a certain price to be paid, even if you have the possibility of dissent.
Thank you.
Okay. Well, collegiality is even more strict in the case of the Italian Constitutional Court. Even if in the composition of the court we have some components that are elected by the parliaments, and so indeed they are chosen also for their political views, their cultural view, let's say. 5 of the members are elected by the parliament. As soon as they become judges, they are expected to strict independence, to silence, not to speak with the media, and to dissolve, in a way, their personality within the court. We do not have dissenting opinion, and I think that this is the major cause of this situation, in which each judge is supposed to give her contribution to the work of the body as such, but not to speak her own voice to the public. The idea of collegiality is really very strict in the Italian Constitutional Court. All the decisions, small cases, big cases, are decided by the plenum, 15 judges, and even the position of the president of the Constitutional Court is considered as a primus inter pares. He's not really marking a difference trend in the case law or in the way the courts behave. Mainly because, first of all, the powers are not that relevant, although we cannot underestimate the power of assigning the cases to each judge for being the main rapporteur of the case. There is also the power that in case of parity, the president's vote is a casting vote, but is very seldom used. But the reason why the role of presidents so far are not so relevant in the Italian Constitutional Court is because usually they have a very short term. I was surprised listening that our colleague is in charge of the Supreme Court since 17 years, whereas we have some cases in which we go that far of having a president for 17 days, maybe. Well, this is an exception, but we really have a very, because it's by seniority so far. It's a debated issue, but so far it's by seniority. I have to add that although I have to agree with the compromising effect of the collegiality rules, which in many cases brings to the decision of the court benefits, because also those that are in the minority are expected to give a contribution to the reasoning of the court. Sometimes the result is that you have contradictory decision because you can recognize different souls of the decision. In exceptional cases, I have witnesses to situations in which the lack of a possibility of spending one's own voice was very relevant, to the point that some colleagues in very divisive cases were to the point of stepping down. And this was the only possibility to have a say on the decision. Okay?
Thank you.
Well, Canada's judicial tradition is grounded in the English approach, which on appellate, at the appellate level, gives each judge a voice and a right to dissent or indeed write collateral opinions. And until fairly recently, historically, one would find that there were often many opinions on a particular appeal. Some people refer to this as the seriatim approach. So it's perhaps most pronounced now in Australia, where I understand from talking to their judges that they don't live and work in Canberra. After their session, they go back to their own state, their own office, and they write whatever they think about the case, and then ultimately all 7 opinions are put together. And sometimes there's agreements, often there aren't 7, but different people see things the same way. But there's no real attempt, as far as I can see, to try to get the maximum amount of consensus. We had some difficult experiences with this seriatim approach in the 80s and 90s. It was an important case, just to take one of several, on constitutional rights, which the lawyers professed anyway, that they couldn't figure out what the case said. There were about 4 points, and there were so many divergences on different points and nuances that the complaint we got from the public and from the legal profession was that the court was not fulfilling its role of clarifying the law. I hasten to say this was before I was on the court, but you can find some examples since I've been on the court too. But anyway, we started to think about this, what our job was as the final court of appeal. And our ultimate obligation under our statute is to decide issues of public law and I think underlying that is a conception that the role of a superior court, a Supreme Court, a final appeal certainly, is to clarify the law so that people know what it is going forward. And if you are giving a lot of divided opinions, 3 or 4 opinions all over the place, it's very difficult sometimes to know what the law emerging from that case is. So after I became Chief Justice, and I don't take credit for this, although I certainly encouraged it, the court came to the view, I think, by consensus without too much discussion, that we should try to do a better job of achieving consensus without sacrificing the right to dissent when you clearly had a different point of view on a principle. We cherish that right. But what we try to do now is have a maximum amount of conversation and discussion about points with a view to arriving, to minimizing our differences and to arriving at a common decision on a particular point. Often this can be done by saying, well, what we're really arguing about is something that's we don't really have to decide in this case. It'll come up again. So let's see how much consensus we can get about the principle as it applies now, and leave some of those peripheral questions for another day. Often it has to do with simply long discussions in which one person ultimately says, well, that was my view, but I see the other point of view, and I think I was perhaps mistaken. And so we have a long period after the hearing when this kind of discussion takes place. Someone writes a majority judgment, what we think will be the majority, and then we have memos, we have conversations in our chambers and in the corridors. We talk to each other about it. Somebody says, I like your decision, but I don't like this. I don't think you're right on that. And so we have this long period of discussion. It can't be over long, obviously, because the judgment has to get out. This is a whole new process of judging for some of our colleagues who come from lower courts of appeal, where they find that consensus emerges more easily with just 3 people, for example. But we have 9 on many cases. And the more people, the more difficult. And it's really, I have to tell you, this is really hard work. It's the hardest work probably that I do, because it involves your basic conviction after you hear the case. I've got it settled in my own mind. I think I know the way it should go, and it involves you opening your ears and your heart and actually listening. Our First Nations people have a way of saying, I hear you. When they do that, you know they're saying not just that I'm listening so I can figure out what the best ploy to defeat your argument is, but I'm really taking it on. And that's the kind of process that I've become used to. And it is hard work. And it's emotionally draining. And sometimes people are frustrated with each other. But you know, we have a level of collegiality that in the end we come through it and we say, that was a good process. And we don't always reach the same view, and sometimes, sadly, we even have 3-3-1 or something. There's no such thing as perfection in judging. But what we do is try for the maximum amount of consensus possible. And I can tell you, when we started doing this, we didn't make a big announcement. We didn't say we were going to do it. But within a year or two, the lawyers, the profession, people noticed. They said, we really appreciate the effort the court is making. Whatever you're doing, it's working. We now know what you think on a certain point. We can advise our clients. We can move forward. So they feel that the court as an institution is doing a better job. The other thing I would say is that there is this tension between the individual and the institution. And sometimes people get named to the court and they think I'm going to come in as an individual, I'll make all the right decisions, everybody will agree with me, and the world will be a better place. But if we take a totally individualistic view, you don't go as far as the Italians, but if we take a totally individualistic view, we will never be a good court of final appeal, because we will not have those deep discussions, we will not have those engagements. And I'll just close with this, because I think it says it better than anything I can say. The first woman on our court was a woman named Bertha Wilson, and she said to me once, when I was a new judge on the court, and we were going through this kind of an exercise, she said, the court is entitled to the decision of 9 members after each of them has given serious consideration to the views of every other member. The public is entitled to that. The public is entitled to more than just 9 individual views. And that, that lesson, that your real job on a final court of appeal is to try to come to the maximum amount of consensus that you can, is a very important one that I have learned in my period of time.
Thank you. This is really fascinating, and I really appreciate, on behalf of our collective here, your openness on this point. Let me just ask you one final question, and then we'll open the floor for a few questions from the audience. So I'm sure you're aware of this. There is much talk in the academia. We are here in the company of hundreds of scholars, young and younger, of public law. There's much talk in the academia about so-called global constitutionalism, convergence worldwide towards or upon constitutionalism, this rise of an Esperanto-like liberal constitutional rights jurisprudence in many parts of the world. Observers have identified the rise of the Supreme Court of Canada, or the German Federal Constitutional Court, or the European Court of Human Rights as the new tone setters in that respect. Courts elsewhere look up to you. Scholars in your own countries and elsewhere carefully read your decisions, scrutinize them intellectually, publish articles. I'm not talking about media commentaries. I'm talking more about academic and judicial analysis of what you do and what you write. Can you share with us your views on this entire universe of public law beyond your own jurisdiction, and mainly, how much attention do you actually pay to doctrinal innovation in the legal academia, or to jurisprudential developments overseas? To what extent these are relevant to your daily craft? And maybe we'll start with Marta now.
No.
Yes, yes. You asked for it.
I should have made that remark.
Yes.
Sorry. Sorry. Well, this is very, very interesting. Let's start from a consideration. The Italian Constitutional Court, in the Italian Constitutional Court, seat a number of professors. A large number of professors in this moment. We have a diverse composition. That we always have some members from the judiciary, but a number of us come from the academy. So if you read a decision of the Italian Constitutional Court, you can easily understand that many of us read and write for the academy. So we can start from saying that there is a mutual fertilization. As a member of the academy, I can bring into the court my views, I write for them, they are ready to criticize, and so there is an improvement and development of the legal scholarship on that base. The question is what kind of academy, what kind of scholarship, because most of us, for a number of reasons, and I don't want to enter into the details, are much more oriented to national constitutional scholarship with a strong specific focus on judicial review of legislation. So we have a very strong decision from the procedural point of view, the way the court should behave and so on and so forth, but not so much concern of speaking to a larger public. The sign of this is that it is only since a few years that we started translating our decision. If you write in Italian, it's only for an Italian audience. Not many other people can read Italian. We started to have a sense of our participation to a global community in the last few years, and the most relevant step that we made was to start to translate at least those decisions that can be interesting for a larger public. There is another thing. You mentioned the fact that I was appointed in 2011, and soon after that I was given the honor of being the vice president of the court, and the actual Chief Justice explicitly asked me to act as a sort of foreign minister of the court, in the sense that there is an increasing attention to the international and global relation of courts in the European context and beyond that. There is a number of networks all around the world where we share views. The European Conference, the Conference of the European Constitutional Court, the World Conference of Constitutional Court. There are a number of bilateral, trilateral contacts, the conference that we held every year with some courts. For example, the Italian court is very close to the Spanish, the Portuguese, and we have a group with them, another group with the German one, we have some contacts with them. But even most important for what can I see from my experience are those forums where different judges and professors meet together in a way that where we can speak openly off records indeed, but where we can share views on common problems, because indeed there are questions of methodological issues and also on the substance that really keep all the courts all over the world busy on the same kind of issues. These moments are the most profitable because we are not there just to speak in an institutional, formal way, but really we can try to understand. That's how I learned from the reasonable accommodation that I was referring before in the previous session. But really we can enrich and bring to our colleagues in our courts what is a good instrument, a good practice that can be implemented everywhere. Thank you.
Thank you. Who wants to go next?
Right. So first, we hardly ever quote a legal authority. The reason is that there is always another legal authority who is not quoted, and we don't want to create embarrassment. That doesn't mean that we are not trying to follow some developments in academia. This is particularly true, even the cutting edge, when it comes to public international law. There, I think those who have a background in public international law, they are very, very active. There are cases concerning limiting state immunity. There, I think the court was moving in that direction, although there is criticism coming from public international law. Audience. Our audience is not the academia. We write to national judges and exceptionally to governments how to implement a prison reform. Now, what is the value of the doctrine? No gossip, but just because I've seen certain things as a greenhorn, later on I started a report. Dworkin has a theory, and there was deadly silence. Once you utter the name of a legal philosopher, that's a kiss of death. And then, of course, I was aware of this. I said, but I'm not going to report because you all know of it. And then, of course, there was the traditional discourse of very self-referential. But it is part of this self-referential is to look at comparative law. This is a standard part in our Grand Chamber judgment to do a comparative research. Canada is often cited, and member state legislation is considered. Now, the problem is that we refer to legislation and not to the criticism, including doctrinal criticism of legislation. So it's a little bit one-sided. That's how it is. And finally, and there are specialists here of this, there is, in this comparative stuff, cherry picking. You choose those examples which prove your point. And even US Supreme Courts are cited in case they support the argument, although this is rather exceptional.
Thank you.
We do practice comparative law. We find great assistance, not in every case, but in many cases, from the thinking of other jurists. And indeed, our charter directs us to indirectly. It says on section 1, which I referred to, that the compromise has to be reasonable. One would be reasonable in a fair and democratic society. So there's even an outward reference within our constitutional doctrine. We're very aware of this because just to the south of Canada is the United States, where for a number of decades, although not necessarily in this is a fairly recent phenomenon historically, but there have been people who, judges who said it was categorically wrong to ever go to another countries or look at what another court had done in a similar situation. But now we're seeing that is even changing on the United States Supreme Court, and Breyer, a number of other judges have come out and said, well, why not? Why wouldn't you? What are we afraid of? The fear in the United States is interesting. I argued with Justice Scalia about this, and Chief Justice Roberts is on record in his confirmation hearings as saying it's too easy just to cherry pick. You'll find, if you want to decide in a certain way, you'll just find something in another foreign jurisdiction, you'll pick it out, you'll plug it in, and there you'll have your decision. And I agree with him if that's how you think comparative law works. That would be very bad judging. But that is not how people on my court think it works, and I hope it's not how we practice it. What we try to do is look at how other courts, for example, the European Court of Human Rights, we don't have too many Italian decisions yet, but I'm glad they're coming, that we can translate easily. We look at what they did in a similar situation. We don't necessarily accept that. We have to examine that in light of our own charter, our own Bill of Rights, our own jurisprudence, and our own society. It has to be grounded in the decision has to be grounded in the context of your society. I find using comparative law properly a sophisticated juristic exercise. It's high-level judging. to quote what one of my friends says. Because in order to use another country's decision properly, you need to thoroughly understand not only that decision, but the context of that country, the context of that problem, their Bill of Rights, and all of that. Only then can you say, I'm in a position to evaluate that decision fully. And after you've done that, then you can look at your own situation and you can incorporate it if it makes sense, and you can take some comfort in the fact that another court respected, that was facing a similar situation in a similar context, came up with this, and more important, gave some very good reasons which may apply in your situation. So I like comparative law, but I would caution that it's not what, with great respect, Chief Justice Roberts painted it as being. It isn't just cutting out a paragraph from somebody else's judgment and pasting it into your own and saying, see, it's much more sophisticated than that. It is a very sophisticated exercise, and the academics among you will understand this, because you know you have to always understand the background of whatever you're citing.
Thank you very much. We have a few minutes left, so I suggest we open the floor and we'll take maybe no more than 3 questions in one round. There is a microphone somewhere in the room. Is that working? Yeah. Okay, so we'll take maybe 3 questions, and then we'll ask the panel participants to maybe cherry pick and because do their best in that. And unfortunately, then our time will be up. Let's start here. You can just be as to the point as possible.
Yeah. Is it on? Erika de Weet from the University of Pretoria. My question is addressed to the 2 national judges, and it concerns the relationship national and international law. Both your courts have a rich tradition also in at times engaging with public international law, and I would just like to hear from each of you which decision in your view was the most important or influential in that regard.
Sorry, the question is? What?
Which decision that affects public international law that was handed down by your court in your view, is one of the most important decisions in that context, that concerns the interface between constitutional law and public international law?
Thank you. Maybe, yes, sir.
Okay, my name is Claudian Rado, and I'm asking a question for Chief Justice McLaughlin. Is the Supreme Court of Canada participating in a transnational judicial dialogue with other courts, national or international courts? And if yes, what are some of the main impacts of this process? For example, do you see impacts on the substantive decision-making, or in court management, or any other impacts from this process?
Maybe we can take one more question. Anyone else? Elaine? And maybe we'll take a 4th one later, and that'll be it. Okay, Elaine. Yes.
Elaine Mack, Utrecht University. Thank you very much for the discussion. I was wondering to what extent you think that digitalization has influenced the work of your court. The possibilities to broadcast court hearings or to find information in databases and, well, to what extent do you think that has influenced, on the one hand, the kind of information that you can use for your decision making, and on the other hand, your possibilities to enter into contact with the general public? Thank you.
Thank you. Maybe one final question at the back, and we'll conclude with that.
Bev Baines, Queens, Canada. I'm very interested in your considering judgments from other contexts. I wonder in that context about the feminist judgments projects. What would it take for you to consider the feminist judgments projects? If you're familiar with them, they come from Canada, the UK, the US, Australia, Northern and Irish, international, but they're written by scholars and judges, depending on the context. If you read them or if you don't, what would make you consider them as judgments that you might take into account?
Thank you. Please.
Well, I'll answer the last one for myself. I'm not familiar with this, but basically our criteria, we're in an adversarial system, and the lawyers who are appearing before us raise the international material we consider. And generally, we stick quite closely to that, and we'll consider anything they put before us.
Thank you.
Okay. On the point of relation between constitutional law and international law, I would say that the most important, I have to mention two decisions. One for the relation with the European Union, it dates back to the 1984, because there you have the idea of opening the sovereignty to limitation in order to allow this participation even from the legal point of view of to the European project. And on the other hand, a similar framework for our relation with the European Convention of Human Rights was elaborated in two decision of 1997. There are differences because the European integration is different from accession to the European Convention of Human Rights, but the two of them are really the pillar on which we build up all the relationship between national constitutional law and international law.
I think first of all, this court, which is overloaded, has 800 million potential applicants and very different audiences. And it's one of our major problems to create support or generate support in this audience. We don't have the tools, we don't have the money, we don't have support from journalists, newspapers. In fact, the archenemy of this court and its legitimacy is the press, or part of it, namely Daily Mail, which is single-handedly destroying the idea of European human rights. So this is something that raises the issue to what extent a court is capable and authorized to mobilize public support in case where it serves that public. But is it legitimate for a court to go to the public directly and try to convince them that we are doing a service to you, you should stand up for us, pressure your government? It's a very, very delicate issue. But without that, we are doomed.
Any final comments?
Well, I agree it's very difficult for courts to defend themselves outside their judgments. We take the view, we speak mainly through our judgments. But more and more in Canada, we have people like me, Chief Justices and Justices of my court, who go around and explain to groups what courts do, how we work, how we go about our business, how we conceive our job. We know we have to be transparent and open, but we can't get involved in a political fray. We hope that the profession will speak up if there are accusations that are false, but judges do fight with one hand behind their back on these things. Aaron Barak, the former Chief Justice of Israel, said that they fight with one hand behind their back, but they will always prevail. So I have days when I'm not so sure, although I respect him intensely, and I particularly respect his optimism. But I do think the public has, there's a strong constituency for justice in the public. And if we can communicate with them that the courts are doing a good job and that we are conscientious and honest in our struggle for getting the just decision, that goes a long way. We televise our proceedings and have for 25 years or more. That it may not be appropriate for a trial court, but it certainly is appropriate for us. So if you are having a sleepless night, you can turn on a public channel and you'll pick up Supreme Court. And people have come to me, and it's more about process than the particular decision. They say, I'm so impressed. Obviously, the lawyers have deeply felt adversarial positions. The judges obviously have different positions. But everybody is discussing this in a civilized manner. And it helps to maintain public confidence. But I do believe, as I said before, that maintaining public confidence in justice and the judicial process is one of our primary tasks, and human rights as well, because that's all part of it. So it's a difficult thing, but I think that we have to be out there for the public. We should be explaining in schools. We should be dealing with younger people. We should be teaching people how important justice and human rights are to the survival of our democracy and the success of our societies.
Well, thank you very much. It's been really a pleasure and an honor to moderate this panel. I know we could go on and on, but we are running out of time, and the next round of panels is just around the corner. On behalf of the International Society of Public Law, again, University of Copenhagen and the I-Courts Center, and everyone here in the room, I would like to really, really thank you and tell you how grateful we are that you were able to share with us your thoughts for an hour and a half. So please join me in